on behalf of the ILSA committee, we are very honored and grateful to have our incredible judges who, despite their busy schedules, need time to partake in the ILSA UniSZA International Moot Court Competition 2022. For judges' information, all oralists are first-timers in international mooting competition, and this will serve as a stepping stone to them in future international mooting competitions. We hope that all of the oralists are prepared and can present themselves in a healthy manner. Give your all while remaining calm and collected. Ladies and gentlemen, now let me introduce our two experienced judges for session 4. Mr. Al-Hanisham Muhammad Khalid will serve as the first judge, and Mr. Al-Hanisham is a law lecturer in Universiti Utara Malaysia, and the second judge will be Mr. Shafiq Sulaiman, a law lecturer in Universiti Sultan Zainal Abidin. Both of our judges are specialized in international law. Both of our judges' expertise are very related to our concerning case in today's competition. For everyone's information, Team 005 has already submitted thrice today, and this will be their fourth oral submission. I hope the judges recognize how ambitious and committed they are to this competition despite their exhaustion. Before we start with the session, let me read the rules for preliminary rounds. In the preliminary rounds, each team shall argue once, either as an applicant or as a respondent, depending on the party assigned. Each team shall get a total of 35 minutes to present their case. This time shall include rebuttal and sub-rebuttal time. The division of time per oralist is left to the discretion of the team subject with a maximum of 15 minutes per oralist. The maximum time period for rebuttal and sub-rebuttal is 5 minutes. The oral submission shall be confined to the issues presented in the moot problem. Maximum scores for the oral rounds shall be 100 points per oralist per judge. No two teams will argue against each other more than once in the preliminary rounds. Both teams should be aware of the time, and the timekeeper will show you a placard indicating how much time you have left. Mr. Ishraf Hassan is our timekeeper for session 4. In this court, pursuant to the application filed in the registry of the court on 10 April 2020, whereby the government of the state of Al-Raja instituted proceedings against the Republic of Ronavo with regard to a dispute concerning alleged violations of international law by Ronavo, and in accordance with Article 48 of the Statute of the Court and to Articles 31, 44, 45, Clause 1, 48, and 49 of the Rules of Court of the International Court of Justice. The parties hereby submit to this court. Al-Raja and Ronavo have appointed their respective agents. And now, I would like to invite our first agent in the Al-Raja team, Team 005, to start with team's short introduction and then proceed with your submission. Good luck, team. Your time starts now.
Good evening, Your Excellencies. May it please the court. I am Carmen, and am appearing alongside my co-agent in this case, Ms. Divya, and we have the honor to appear on behalf of the applicants in this case, the State of Eurasia, and my learned agents for the respondents, the Republic of Ronavo, Mr. Hardy and Mr. Kamar Zaman. I will submit first for 15 minutes, and Ms. Divya will submit another 15 minutes. We reserve 5 minutes for rebuttal. Your Excellencies, I will be submitting that the Sapir Island belongs to Eurasia, and that Maru can intervene in the case between Eurasia and Ronavo. Ms. Divya will demonstrate that Eurasia is not liable to compensate the respondents for the damage suffered by the HMS Gong Hippo and the HMS Gong Jimmy. Before I begin with my submissions, would Your Excellencies like a summary of the facts? Your Excellencies, would you like a summary of the facts?
Yes, please.
Much obliged. I will now begin with the summary of the facts. Eurasia is a developing island country located in the northern part of the Asian continent. It is divided into 2 administrative areas, the Aman United in the east and President Amara as the de facto president in the south. Most countries consider both areas the same country, but both areas are in conflict and hostile towards one another. Ronoval is a developed mainland country located in North America. It is a party to the North Atlantic Treaty Organization. Both countries are parties to the Charter of the United Nations, the Statute of International Court of Justice, the United Nations Convention on the Law of the Sea, and the Vienna Convention on the Law of Treaties. They are not parties to any other treaties. The St. Pierre Island is located 12 nautical miles off Eurasia. The island belonged to Eurasia, but has been administered by Ronoval over the course of the last 53 years through the establishment of a lighthouse and a helipad. Imaro, a neighboring state of both Eurasia and Ronoval, claim to have consistently claimed the area of St. Pierre Island. The HMS Gong Hippo is a naval ship of Ronoval. On November 10, 2020, it collided with one of the naval mines belonging to the Navy of Eurasia. The collision occurred in the Barents Sea near the Kota Peninsula. The ship was severely damaged and the total loss was estimated at $125 million. Ronoval contested that the naval ship was exercising its right to innocent passage under international law, and Eurasia should not interfere. However, Eurasia had consistently warned the HMS Gong Hippo of encroaching into its territorial waters, but the HMS Gong Hippo continued to stay in that area. To safeguard the area from the naval ship, the National Coast Guard planted a dozen naval mines, one of which the HMS Gong Hippo collided with upon leaving the area. The HMS Gong Genie is also a naval ship of Ronoval. On the 21st of December 2021, it was attacked in its territorial waters by a boat consisting of 5 members of the Amen United Group. The naval ship was attacked with various weapons for about 15 minutes. Parts of the ship were destroyed, and 6 sailors, including the captain of the naval ship, perished. The president of Ronoval condemned Eurasia for the incident, but Eurasia proclaimed that it should not be held responsible for the actions of the Amen Group, which was not directly under its control. On the 24th of December 2021, Ronoval launched a concerted attack on the territory of Eurasia in which hundreds of military assets were mobilized. The attack destroyed various military and civilian structures of Eurasia, including important harbors, oil platforms, and an airport. A number of persons, including citizens of foreign countries, were killed. On the 25th of December 2021, the president of Ronoval stated that the attack was made in self-defense, in the spirit of the United Nations Charter. The act was universally condemned by all other countries, and they urged Ronoval to consult the Security Council first. On the 15th of January 2022, leaders of both countries met to discuss the incident. Your Excellencies, may I begin my submission?
Yes, please.
Much obliged. The applicants would like to first submit that the St. Pierre Island belongs to Eurasia. We submit 2 major bases for this. First, that the St. Pierre Island legally belongs to Eurasia pursuant to the United Nations Convention on the Law of the Sea. Article 3 of the United Nations Convention on the Law of the Sea regarding the breadth of the territorial sea states that every state has the right to establish the breadth of its territorial sea up to a limit not exceeding 12 nautical miles, measured from baselines determined in accordance with this convention. And if I may, I would like to request for Your Excellency's attention to refer to the Statement of Facts, page 7, paragraph 6, line 3. Here it states that the St. Pierre Island belong to Eurasia. Eurasia and Ronoval are states which are parties to the United Nations Convention of the Law of the Sea and are thus bound by it. It is also agreed upon that the St. Pierre Island is within the limit of 12 nautical miles of Eurasia.
Agent, I have a question. Since you mentioned about territorial sea, does it even relevant for sovereignty of an island to be determined through the distance? I mean, the closer they are to one country, so those islands belong to that country. May I know what authorities you rely on?
Thank you very much for your question, Your Excellency. The authority that I'm relying on is this convention itself, which is it is not the distance of the island between the territory. Sorry, the distance of the territory of the island. It is not the only determining factor that the island belongs to a state. However, it is a very important factor that should be kept in mind while making a judgment or a decision upon this case.
Agent, could you deal with the facts that there have been establishment of a few structures, and then there have been Ronaldo has been in control of the island for a long time. That proves the sovereignty belongs to them, not to your country.
Thank you very much for your other question, Your Excellency. In regards to your question, I would like to refer to the case of Indonesia and Malaysia concerning the sovereignty over Pulau Ligatan and Pulau Simpadan in 2002. The court observed that the construction and operation of lighthouses and navigational aids were not normally considered manifestations of state authority. In the case, the court also referred to its judgment on the case concerning maritime delimitation and territorial questions between Qatar and Bahrain in 1994, which stated that the construction of navigational aids, on the other hand, can be legally relevant in the case of very small islands. However, according to the statement of the facts, St. Pierre Island is not considered a very small island. It is not defined as a very small island. Thus, it cannot be said that the actions taken by Ronaldo on that island can be considered as legally relevant or as having performed acts of a sovereign nature over the island.
Agent, could you define what is island according to international law? What's the definition of it?
Unfortunately, Your Excellency, I will not be able to assist you with your question. However, that we are referring we are referring to the statement of the facts. And in the statement of the facts, it is not stated that St. Pierre Island is a very small island. Thus, the actions taken by Ronaldo cannot be determined as being acts of a sovereign nature over the island. Okay, so the next thing that I would like to mention is that Ronaldo has insufficient proof that the St. Pierre Island belongs to it. The burden remains at all times on the respondents to produce specific proof that it has sovereignty over St. Pierre Island and carried out acts of a sovereign nature over the island. In reference to the case of Cambodia and Thailand concerning the Temple of Preah Vihear in 1962, it is stated that the burden of proof in respect of the facts and contentions on which the respective claims of the parties are based will, of course, lie on the party asserting or putting them forward. Thus, the actions of Ronaldo cannot be said as having been performed acts of a sovereign nature, and they cannot prove that they have sovereignty over the island. In conclusion, on behalf of AirAsia, the applicants respectfully request that the court adjudge and declare that the sovereignty of St. Pierre Island belongs to AirAsia.
Agent, I have a question here. Since you argue about sovereignty, could you define what does it mean by sovereignty, and how is it even relevant within the context of your case?
Thank you very much for your question, Your Excellency. Apologies for the delay. Sovereignty is defined as the supreme power or authority, and sovereignty means that the state is able to govern itself of another state, its governing power. So in order to, a supreme power authority who by law possesses a right to announce and to do their collective will in the form of public laws when another body of individuals within the same state possess the physical power to disobey such laws without liability to punishment. I hope that answers your question, Your Excellency. Okay, then I will now move on to the second submission of the applicants, which is that Imaro can intervene in the ICJ proceedings involving AirAsia and Ronaval. Imaro has the legal right to intervene in the ICJ proceedings involving AirAsia and Ronaval, pursuant to the statute of the court. In Article 62 of the statute of the court, it provides that 1. Should a state consider that it has an interest of legal nature which may be affected by the decision in the case, it may submit a request to the court to be permitted to intervene, and 2. It shall be for the court to decide upon this request. As Imaro claims that its fishermen have been fishing around the island for centuries, it has an interest of legal nature regarding the sovereignty of St. Clair Island. Thus, Imaro will be affected by the decision in the case. So Imaro may submit a request to the court to be permitted to intervene in the case, upon which the court will decide upon the request. Therefore, Imaro has satisfied the first requirement of Article 62 of the Statute of the Court to intervene in the ICJ proceedings involving AirAsia and Ronaval. I will now conclude my second submission. That the applicants acknowledge the right of Imaro to intervene in the ICJ proceedings involving AirAsia and Ronaval. If I can be of no assistance to the court, my co-agent, Ms. Divya, will proceed with her submissions.
Thank you, Ms. Carmen. Yours Excellency, moving on to my third point, that AirAsia is exempt from responsibility for providing Ronaval the damages for the HMS Kongkipo and compensation for the loss of the ship. Under the international humanitarian law and United Nations Convention of the Law of the Sea, operations AirAsia will not be liable to compensate Ronaval for the damages suffered by HMS Kongkipo. Under international humanitarian law, jus in bello regulates the conduct of forces when engaged in a war or armed conflict. It's distinct that from jus ad bellum, which regulates the conduct of engaging in war or armed conflict and includes the crime of aggression. Together in the jus in bellum and jus ad bellum comprise the two strands of the law of war governing all aspects of international armed conflicts. The law is mandatory for nations bound by the appropriate treaties. Your Excellency, please do refer to the Moot problem, page 7, paragraph 5. It is stated that President Harris then ordered 3 nuclear-powered submarines and 4 aircraft carriers to relocate to the Barents Sea. President Amara, fearing the safety of his nation, called the Russian president, Mr. Putin, and asked for the military assistance. This means that war is prohibited. The threat or use of force against other states is also prohibited by United Nations Charter. Since 1945, war has been seen as unacceptable means of resolving interstate disputes. As a result, threatening a nation with a military strike is against the humanitarian law. A state is said to have undertaken an internationally wrongful conduct, which is a violation of international law. When it violates any of the treaties to which it is signatory or when it disobeys globally accepted conventions and rules, in such circumstances, a state may be found in violation of international law and subject to repercussions. Next, I'll be moving on for the next clarification, which is hitting naval mines and demand full responsibility, which does not seem right from the perspective of United Nations Convention of the Law of the Sea. Sovereign waters and international water, since ship of all nations enjoy the... Yes?
I have a question. So since you are using legal analysis on war, is there even a war definition of war within the context of the facts?
In the context of the past, facts, war wasn't declared, but threatening against war was done by Ronald towards Russia. Yes, Excellency. Can I continue?
Yeah, sure.
So sovereign waters and international waters, since ships of all nations enjoy the right of innocent passage through the territorial sea and archipelagic waters. A state rights to lay armed mines in this water is tempered by its obligation not to hamper the appropriate passage to foreign ships. A coastal is entitled to suspend innocent passage to protect its national security and for weapons exercises. But in such circumstances, the suspension must be temporary and only in specified areas of its territorial sea. In other words, the right to do so is exceptional. Your Excellency, please to refer to the Moot problem, page 7, paragraph 5. It is stated that Russia claimed that the ship had encroached into its territorial waters, and after consistent warning given out by National Coast Guard, HMS Gong Kipo failed to pay heed but continued its stay in that area. The National Coast Guard decided to plant a dozen of naval mines to safeguard the area from further intrusion by the naval ship. So it also means that the barons were not regarded as high seas, so the ship lacks legal authority to exert innocent passage. Because passage is innocent so long as it does not adverse to the peace, good order, or security of the coastal state. Ronald said that even if the area was not considered as high seas, the ship was exercising the right of innocent passage under international law. Under this condition, passage of foreign ship shall be considered as prejudicial to the peace, good order, or security of the coastal state. If it yes.
Where is, could you tell us the specific place where the event actually occurred? Is it within territorial sea of Russia or is it in high sea?
It happened at the territorial seas of Russia, which is at Barents Seas.
Are you sure?
Yeah, I am very sure. So under this condition, foreign ship shall be considered to be prejudicial for this peace. Therefore, Republic of Renewal is not accountable for claiming that it accidentally hit mines that were set out for security purposes. Your Excellency, without further interruption, I would like to move on to issue 4, which is Russia is not liable to compensate Renewal for the damages inflicted to HMS Gongjin. There are currently 2 administrative regions in Russia. First is President Amara in charge of the south, and the second one is at the east, which in charge of Amen United, a paramilitary organization. However, on a global scale, the majority of nations regarded both regions belonging to the same nation. The group of administration of President Amara frequently engage in intermittent acts of violence against one another, particularly near the border separating the two regions. Since the part of Eurasia spill between two regions, the de facto boundaries applied for these two regions, where de facto means boundaries of countries which defined by the area that its government is actually able to enforce its law and defend against encroachments by other countries that may also claim the same territory de jure. The following actions, though not all of them, are considered as acts of aggressions under UN General Assembly Youth Resolution.
Agent, I'm not really sure about the relevancy of differentiating between de jure and de facto. How is it the difference actually affects your case?
Thank you for the question, Sales Excellency. De facto, as I said, is a boundaries of that defined area. But how de jure applied towards the country is that I'm sorry, I couldn't able to assist you on that. Sorry. To the last point, my submission. So the parliamentary organizations aims at that is not responsible by Arasia. And for the foregoing reasons, I respectfully request that court find a favor of on the Republic of Runawal on violation of acts of aggression under UN General Assembly resolution that does not apply for Arasia. Thank you.
Just now. Thank you for your part. Any additional comments or questions from the judges? If no, we're going to proceed with team respondent. Team respondent, your time starts now.
Good afternoon, Your Excellency. May it please the court. My name is Muhammad Kamal Zaman, and I appear for the respondent, the state of Runawal, along with my co-agent, Hadi Aris. I'll be speaking first for 50 minutes. My co-agent will speak second for 50 minutes. We reserve 5 minutes for rebuttal. Your Excellency, I will now proceed with the first question regarding the Saint Pierre Island. The state of Runawal believes that the Saint Pierre Island belongs to Runawal. In addressing this claim, we have 2 points to make. The first is Runawal has carried out numerous sovereign acts over Saint Pierre Island and within its territorial waters. Runawal has engaged in frequent naval patrol in the territorial waters around Saint Pierre Islands. This activity was carried out by Runawal without seeking any authorization from Arasia. The establishment of Navy patrol and the conduct of Navy patrol is a further evidence of Runawal lost standing title over Saint Pierre Island. Your Excellency, there can be no doubt that Ronaldo displays and always display power and authority over the island through the administration and constant uninterrupted activities on St. Pierre Island. Your Excellencies, not only that, in contrast to Ronaldo, Arasia persistent silence in 53 years has threatened the fact that the island belongs to Ronaldo. If Arasia believed that she had a claim over St. Pierre Island, one would have expected Arasia to interfere with Ronaldo's sovereignty and administration in St. Pierre Island. There were certainly many opportunities for Arasia to intervene with Ronaldo's administration by taking the position of the island to build a lighthouse.
Agent, how about the locations of the island? It is within territorial sea of Arasia. Certainly it belongs to Arasia, isn't it?
I believe the St. Pierre Island is within Arasia territorial waters.
So that shows the island belongs to Arasia because it is within their territorial waters.
If you want to answer this question, we have to refer with the Pedra Blanca case. In the Pedra Blanca case, the Pedra Blanca was located in the territorial waters of Malaysia, and the court decided with the factors that Singapore the ignorance of Malaysia to act as sovereign on the Pedra Blanca for 150 years, and the court decided that the Pedra Blanca belongs to Ronaldo. It belongs to Singapore. Yeah, that answer your question.
Could you elaborate more decisions, the ratio decidendi of the case? Why is the reason Pedra Blanca belongs to Singapore instead of Malaysia?
If we want, the reason why Pedra Blanca belongs to Singapore can be divided to two reasons. The first is Malaysia persistent silence. Malaysia stays silent and aware that Singapore administration for 130 years, and Singapore conduct its sovereignty without any interruption from Malaysia. And the second one is the building of the lighthouse on the Pedra Blanca. If we look to the case, Singapore used the Singapore used the case in the forgive me. Singapore used the case in the legal status of Eastern Greenland case, Denmark and Norway. In that case, the court has stated that it is impossible to read the records of the decision in cases as to territorial sovereignty without observing that in many cases, the tribunal has been satisfied with very little in the way of the actual exercise of sovereign rights, provided that the other state could not make out a superior claim. This is particularly true in the case of claims to sovereignty over areas in thinly populated or unsettled countries. This case is the same as Ronaldo, as the building of the lighthouse and the Navy patrol is an evidence from Ronaldo that the exercise is exercised on the island.
How about the period of 53 years according to the facts? Do you think 53 years is too short to show anything? It should be at least a few hundred years if a country were to ignore an island.
Okay, if you look at those 53 years, we all can acknowledge that it is a very long time. In those 53 years, Ronawal has exercised its authority and sovereignty by building the lighthouse and the helipad. From these 53 years, we can conclude many investment and lot of efforts has been invested to the island. Arsia cannot now attempt to claim the island belong to her after being ignorant for narrow activities for 53 years. Therefore, it can be said that the island is belong only to Ronawal and not the other countries.
Did the court in Pedra Branca case mention about how many years Malaysia has ignored Pedra Branca?
The court has stated that Malaysia. Okay. Excuse me. Okay. The court stated that in Pedra Branca case that Malaysia has silence for more than 130 years, and Singapore sovereignty proceed without any intervene from Malaysia.
Okay, very well. Are you familiar with the case of what's the case between Thailand and Cambodia? If you could assist me on that case, the name of the case.
I'm sorry, I'm not familiar with that case.
Okay, so we go back to Pedra Branca. It's 100 years and plus. So this one is 53 years. How do you justify ignorance of half the period?
We can justify this half of period. This half of period cannot be considered a short time because it is half. It's 53 years. It's been a few decades. It's been 5 decades. And in these 5 decades, we can conclude that many investment and from Ronald that many investment from Ronald will be raised if the island is being passed to Arasia. Can I proceed with my second point?
Yeah, sure.
Your Excellency, the second point I want to establish is the construction and continued maintenance of the lighthouse of Saint Pierre by the state of Ronawal. Ronawal has shown its constant stream of state activities on Saint Pierre itself. This included building and maintaining the lighthouse, and Ronawal also built the helipad in the Saint Pierre Island. In the past, the court has been satisfied with very little terms of the actual state exercise of state authority to uphold our small island. For example, the court take the same position in Kata Baring case. The court noted that purely private activities such as the drilling of artesian well were controversial as performed as a sovereignty to the island. The court held that the construction of navigational aids on the other hand can be legally relevant in the case of very small island. It should be noted that the construction of the lighthouse maneuver on CPA Island is far stronger than the past case that being examined by the court in the Malaysia and Indonesia Pulau Legitan and Sipadan case, which Malaysia only relied on the fact that navigation aids then be built on both of the dispute island and the collection of turtle aids then be regulated. You can see if there is no question regarding the first issue, I will now proceed to the second issue.
I have one question, Eugene. Could you assist me if there any encounter with the fishermen or anything, who go fishing around the area of the island? If there any statement on that, thank you.
Can you repeat this question?
My question is, any fishermen activities around the island by the other country? Thank you.
Okay, if you look to the statement of the fact, there were Imaro fishermen that been fishing in the nearing the Saint Pierre Island. Okay, is that the answer that you want?
Thank you very much. That's all.
Okay, I will now proceed to the second issue. Your Excellency, in addressing the second issue, we have 3 points to make. The first is we submit that Imaru intervention should be granted. The second is we submit that Imaru has demonstrated that it possesses an interest of legal nature which may be affected by a decision in the case. Third one, we submit Imaru's nature interest. Paragraph 1 of Article 81, the statute of the court, provided that the application for permission to intervene shall be filed as soon as possible and not later than the closure of the written proceedings, and that exceptional circumstances. Any application submitted at a later stage may, however, be admitted. Imaru clearly made a statement before the written proceeding to the court by Arasia and Lawal. The claim of ownership over the area that is still not brought to the ICJ for adjudication may Imaru have a chance to intervene in the present case. It is crystal clear that Imaru is aware and the application of the intervention will not delay the case between Arasia and Lawal. Imaru intervention should be granted by the court. Your Excellencies, the second point we want to submit is Imaru has demonstrated that it possesses an interest of legal nature which may be affected by a decision in the case. According to other Article 62, the Statute of International Court of Justice, as the statute stated, should a state consider that it has an interest of a legal nature which may be affected by a decision in the case, it may submit a request to the court to be permitted to intervene, and it shall be for the court to decide this request. Imaru's statement that the area has been constantly claimed by her country demonstrated that the legal nature of Imaru will exist and fisheries activity affected by the decision of the court. Your Excellency, it should be noted that this case is clearly different circumstances than the Philippine application for permission to intervene in the case concerning sovereignty over Pulau Legitan and Sipadan, which the court decided there is no legal nature in the Philippines' purpose of intervention. Your Excellency, moving to the third point, the court need to consider the nature of the interest capable of justifying an intervention. Imaru nature interest is the same nature as Lonawol and Arasia to claim Sepia Island as her own. The public statement made by Imaru stated that neither Arasia or Lonawol have a right over Sepia is a proof that Imaru clearly seeks to become a party to the dispute submitted to the court by Arasia and Lonawol. Your Excellency, in the majority of the application for permission to intervene that have come to the court, the intervention state have claimed to have an interest in the subject matter of the dispute in the country, in the territory, in where a request of intervention under Article 62 has been granted by the court. For example, in the case between El Salvador and Honduras, application to intervene judgment which Nicaragua rights in the Gulf of Francesca necessarily being affected by the decision of condominium. Apart from that, the present case have a same circumstances with equatorial application to intervene in the boundary between Cameroon and Nigeria, case that has been authorized by the court when equatorial Guinea maritime rights are affected by the determination by the court. Okay, that's all for me. If I can be of no further assistance, this concluded my submission.
Just one more question. So you were saying that Imaru has no legal interests. Did I get it right?
No. I said Imaru has legal interest.
So Imaru can intervene in the proceedings.
Yes.
Okay.
If I can be of no further assistance, I ask the court to reverse.
Thank you.
Okay. Thank you, Team 006. And now we will start our rebuttal and surrebuttal session. 5 minutes for each team, starting with Team 005. Team 005, you may start now.
how about the other agent? I think Mr. Hardy is the second agent.
Yes, sir. I am the second.
All right, please proceed.
Okay. Your Excellency, may it please this honorable court. My name is Hardy, and for the next 70 minutes, I will be pleading on the behalf of the respondent on the third and the fourth issue. I will now proceed with my submission. Your Excellency, Russia is obligated by international law to make amends to Ronaval for the harm they caused to HMS Gonjini. Russia cannot argue that the sinking of this Navy vessel was in self-defense and therefore justified because of the absence of the other requirements required for an armed attack. As a result, under Article 51 of the United Nations Charter, Russia cannot claim self-defense because it failed to notify the Security Council of the attack in timely manner. Russia's right to self-defense is impeded by this. Your Excellency, not only that, it was a violation of international law since Russia's attack on the HMS Gonjini was illegal and it violated international law. In other terms, the assault cannot be justified using force against a military vessel while the world is at peace. It's improper. The vessel in issue have been proven to be naval ship. It is a grave violation of international law for Russia to deny the soldier on board the right to leave due to the illegal action. Russia's state responsibility is overlooked. So, Your Excellency, in addressing the third issue, we have 2 points to make. First, we submit that Russia is liable to compensate Ronaval for the damage by the HMS Gong Hipo. Second, we submit that the right of innocent passage for the HMS Gong Hipo. Your Excellency, Russia claimed that the ship has entered its territorial water without permission in the current instance, but according to the Article 87 of UNC clause, the ship is like a nation that is free to travel to every other country and has access to it on the high seas. Also, according to the Corfu Channel case, a neighboring state, Russia should have been aware of the naval mines earlier. It did not matter where the naval mines were placed in the region. So Ronaval lost a navy ship due to Russia's failure to fulfill a legal obligation, which resulted in a loss of life that cannot be replaced. So Russia should pay the compensation for the
Agent,
loss. Yes.
could you deal with the facts that it was your country who came too close to another country, a hostile country? So what Russia has done is a matter of self-defense. They are protecting themselves. How are they going to let the ships to be within their territorial sea? So this is a legitimate action of self-defense. What's your submission?
Your Excellency, we submit that, just like I said earlier, according to Article 87 of UNC clause, the ship is like a nation that is free to travel. So which means what is Russia did is not a self-defense, but it's on their own obligation to do it. So it's really breached the Article 7 of UNC. So I hope that assists your answer, Your Excellency.
Could you elaborate on a principle of self-defense under international law and how it relates to your submission?
I'm sorry, sir, I cannot assist with you with that question. So, continuing my previous point, as a result, it can be concluded that HMS Gong Hipo was on the high sea. Russia claimed that the ship has entered its territorial water without permission in the current instance, but according to Article 0, the ship is like nation. So, Ronaval, oh, I'm sorry. So, as a result, it can conclude that HMS Gong Hipo was on high sea. So, for the second issue that is for the right of innocent passage,
Agent,
according to
how do you know? How do you ascertain that the ship is on the high sea? I think the facts clearly show the ship is on the territorial sea.
I'm sorry, Your Excellency, I cannot assist you with that question. So moving on to the next point, Your Excellency, for the right of innocent passage, according to Article 17 of UNC Clause, ships from all states, regardless of whether they are coastal or landlocked, are granted the right of innocent passage. Furthermore, if a passage does not jeopardize the state peace, good order, or security, it is considered innocent. According to Article 19, Paragraph 1 USN Clause, coastal states are required under international treaty to ensure that their territories are navigable and to warn other states of any threat to navigation that they may be aware of under Article 14 of UNC Clause. So, by applying to this provision into this case, Russian naval mine were responsible for the attack on a Chinese ship that were exercising its religious right to innocent passage under international law. For example, as outlined in Article 14, a coastal state must not hinder innocent passage and warn any potential danger in its sea. So, according to the 1958 Convention of the Law of the Sea, Russia, on the other hand, is obligated to compensate vulnerable for the loss of life and property because of the current situation. Your Excellency, if there is no question regarding the first issue, I will now turn to the second issue.
Agent, regarding the compensations, on what ground, on what legal basis that the compensations that Russia is should pay compensations?
I'm sorry, Your Excellency, I may not assist you with that question. So moving on to the next issue. In addressing the first issue, we have 2 points to make. First, we submit that the right of innocent passage for HMS Gongjeni. Second, we submit that the HMS Gongjeni was on the high sea and had the right to navigate freely. Your Excellency, on the 21st December 2021, a boat carrying 5 members of the Ayman United Group attacked a Royal Naval Navy vessel at cruise in Royal Naval Territorial Sea. Rocket launcher, assault rifle, and machine gun were among the weapons deployed by the crew of the assaulting vessel. Due to the onslaught, the assault effectively damaged the upper deck and the front area of Navy ship. 6 sailors, including the ship captain, were found to have perished as a result of the internal fire on the Navy ship. As was discovered in retrospect, the HMS Gongjeni was in its area and had every right to innocent passage. But due to the attack, the ship was damaged and lives were lost. Consequently, Russia must compensate HMS Gongjeni and the family of the laying service. Your Excellency, furthermore, for the case regarding HMS Gongjeni on the high sea, according to Article 1 of the Geneva Convention, all seas area not a component of state, territorial sea, or internal water that refer to the high sea. Also, according to Article 87 of UNC Clause, that all the high sea are accessible to all states and need to exercise the freedom of the high sea with the proper regard and respect to the convention. Your Excellency, the Navy ship HMS Gongjeni is free to go to any country and enjoy access to the high seas, just like all other nations. Therefore, nobody can claim dominion over the ocean. Ayman United, a component of Russia, utilized a variety of armament against the UMS Gongjeni, resulting in the yes, Your Excellency.
Ayman United is not a part of Russia. I believe the facts are very clear about the differences between, on one side, it is a government, democratic government. On the other side is another part of the country that is controlled by Ayman United. How could you how is it possible that the action of Iman United is under responsibility of ARASIA?
To assist you with that question, I believe in the statement of the fact. I will rephrase it back. ARASIA is a developing country that is divided to different administrative areas. The east is controlled by Iman United, while the south is controlled by President Amara. Both areas have been considered as de jure the same country. I hope that answer your question. Okay, Your Excellency, the HMS Gunjini was international water and had freedom of navigation. Consequently, ARASIA is responsible for compensating Ronaval for the damage caused by the ship. Mr. President, Your Excellency, if I can be no further assistance, this conclude the respondent submission.
Yeah, please proceed.
May it please the court.
Section, 5 minutes left each team. Team with team 005. Team 005, you may start now.
Yours Excellency, I would like to review three points of our opponent's issue. First one is the right of innocent passage. So as they stated that according to Article 84, freedom of the high sea are open all states, whether the coastal or landlocked. And freedom of the high seas is exercised under the conditions laid down by the convention and by the other rules. Your Excellency, please refer to the Moot problem on page 6, paragraph 4. It is stated that Ronaval state, even if the area was not considered as high sea, the ship was exercising the right to the innocent passage, which claims that Ronaval itself does not sure that Barents Sea was high sea. The Barents Sea were not regarded as high sea because in maritime law, all parts of mass saltwater surrounding the globe that are not part of territorial sea or international waters are considered as high sea, and Barents Sea is known as territorial sea of ARASIA. And according to page 7, Moot problem, page 7, paragraph 5, our government already won that HMS Gongkipo, but ship failed to pay heed. So even if they were unsure if the area was high sea, we have already won them multiple times regarding this, and this threatened us. The second point that we are going to rebut is that compensation for HMS Gongjini. ARASIA is known as an autocratic country, and the system of an autocratic country does not outline the responsibility of ARASIA and President Amara in international level only, but both sides are consistently involved in sporadic acts of violence. Thus, President does not have the authority or control over the actions of Iman United Group, which is also known as the paramilitary group of ARASIA. That's all.
Thank you.
Any additional questions or comments from the judges?
None for me at the moment. Thank you.
Mr. Shafiq?
So I thought there will be rebuttal. There's no rebuttal.
Yeah, so we can proceed now with the rebuttal for team 006. Your time starts now.
For the rebuttal, for the first rebuttal is that even though our Arasia has won on our ship, that to stay away from the dirty waters, there is a law that never mind cannot be used in the international law. So the uses of never mind is a violation of international law, even though it is for the safety of the country of the state. Okay, that's all for me. Okay. That concludes our rebuttal. Our rebuttal.
Any questions or additional comments from the judges?
Thank you. I have none at the moment.
All right, thank you, Mr. Al-Hanisham. Mr. Shafiq?
Yeah, no comments.
All right. Thank you for both judges, and both applicant and respondent team were tied. That concludes session 4 for today's oral submission. I would like to remind all of the judges to email us the score sheet as soon as this session ends. As a member of the ILSA committee, I would like to thank Mr. Al-Hanisham and Mr. Shafiq for sitting there with us as judges in this competition. Thank you all and have a good day. All right, thank you, everyone.